Welcome to the Very DAO channel. My name is Lisa Davis, and I am a member of the Very DAO. Today, we're going to begin a series on the recent Amicus brief that the Very DAO has filed into Southern District of New York in the SEC versus Ripple case. We're going to take some time to let you know the motivation and the background and the intention so that you can see where we're coming from on all of that. We'll be right back right after this. Trey, welcome to the Very DAO channel. Thanks for joining me here. I wanted to jump into, I know we've had the announcement, the timestamp is out, and everyone is quite excited about all that's happening. I think there's been some precedent set in the SEC versus Ripple case. But just to back up a little bit, if we can kind of tell everybody kind of where we're coming from, where the Very DAO is coming from, and who they are, and how the DAO got started.
Yeah, big day, really big day. We've been working on this for months. The Very DAO is an interesting organization. We were formed shortly after the government brought its case in 2019 against Reggie Middleton and Veritaseum. The many members of the Very DAO have been involved in the project since the initial distribution offering in May of 2017. And we feel the project was gaining a lot of momentum. It was they formed a platform. They veritized, and for those that don't know what veritized means, it means that they tokenized real world assets like palladium and silver and gold, and I think they did tax credits as well. And Reggie's idea was to create peer-to-peer capital markets, and that means that Lisa and I, if we wanted to, if I had an asset that Lisa wanted and she had some value she wanted to exchange with me, then we could exchange that value peer to peer, person to person, without a third party intermediary acting on our behalf, like a broker or a bank. And it was so revolutionary and it was gaining steam. And then in 2019, the US government and the enforcement arm of the SEC brought a lawsuit against Reginald Middleton and Veritaseum Inc. And that pretty much froze things in its tracks. So after that, the Veritaseum community was kind of left wondering, well, Reggie has stopped innovating, has stopped developing and the platform because he had to go into a settlement agreement with the SEC. And in that agreement, he agreed not to create any more digital currencies, digital assets, or to handle any Veritaseum tokens. So it left a lot of us wondering what we held in our hands. And so as we kind of congealed into a group of folks who had something in common, we started to develop some ideas about how we could support Reggie and his goals of continuing on with the Veritaseum platform while staying within the legal framework that that most of us in the United States have to fall within if we want to be on the up and up. So
How would
we
you?
formed.
Oh, I'm so sorry.
No, go ahead.
How would you describe the community of the Very DAO, the people that are in it, and the community that was brought together?
A lot of people have a misconception on what the Very DAO is because a lot of people have seen other DAOs come together. A comp is formed a DAO. Makers formed a DAO, and those DAOs all had one thing in common: they had a for-profit motivation. The Very DAO is, and you can see this in the first page of the Amicus. I wanted to back up just a little bit in this. And what I wanted to accomplish with you is I wanted to break down what the motivation and intent was of the members of the Very DAO, because sometimes it's hard to read a legal document and kind of discern what the motivations were. Are they trying to promote the very token? Are they trying to promote the Very DAO? Well, the answer to both of those questions is no. We're not trying to promote the very token. We're not trying to promote the Very DAO. We're trying to present the truth and our story and the XRP token holders and Ripple in their motion for summary judgment. And as I was saying before, most people think that a DAO is a for-profit digital asset community that's looking for ways to make more money, and that's not who we are. On the first page of the Amicus brief, I'll quote it and paraphrase it here under identity and interest of the Amicus Curiae. The Very DAO formed a Wyoming limited liability corporation, the Very DAO LLC, so that we could have legal standing and do things such as file an amicus brief. We're a diverse community. We have members as young as 20, as old as 72. We have members from all socioeconomic backgrounds. We have ladies, gentlemen. So we're a very diverse community, and we're composed of media personalities, small business owners, engineers, entrepreneurs, retirees, and coders who are passionate about the potential of peer-to-peer capital markets and the disintermediating of financial systems for the benefit of inventors and innovators. So Reggie's original vision was to kind of take the rent seekers, the people that would take out a good chunk of a good idea or a good company before it got to market, and give that back to the innovators and the inventors. And so I do want to say that none of the participants in the Very DAO are paid. We all volunteer our time and our energy and our efforts to make sure that our goals are met. And if you look on our Twitter page, you can see that we're kind of a loose organization of folks who've come together to find partnerships for Veritaseum. But we also want to tell the story of token holders, because oftentimes these big corporations, VC firms that are backing some of these crypto projects take a lot of the equity in that project. And we want to tell the story of everyday man, woman who is interested in invested in cryptocurrency. And we think we have a very unique story to tell.
Definitely. So can you tell me a little bit about some of the past actions or the history in the Veritasium DAO, the Very DAO?
Sure. Well, we were kind of, like I said, we were kind of left wondering what we held. We held a digital asset. It was, the internet platform, the inventor of the cryptocurrency, was attacked by the government. He had to settle or else he would have went bankrupt. He didn't have billions of dollars like Ripple has. But afterwards we were wondering what we held, so we filed a FOIA request to get some information from the SEC about their interaction with Reggie Middleton and Veritaseum, and also some of their interactions with Very token holders during the prosecution of Reggie. And we spent a lot of time and a lot of energy learning ourselves how to file Freedom of Information Act requests. I think we filed several of those on several different issues, all of which went unanswered. After that, we decided that we would hire an attorney and maybe get a bigger voice and some more information by filing for a no action letter excuse me, with Jeremy Hogan, who a lot of people in the crypto community will recognize from his YouTube videos. Jeremy did a fine job at representing the Very DAO. He made a very cogent argument about our position and the information that we were seeking. Again, we're a group of people who have worked hard all of our lives to start businesses, raise families, enjoy the freedoms that this country has given us. And we want to stay within the legal framework that the U.S. Has allowed us to prosper in. The last thing that we want to do is to go foul of the legal framework. And I think that's part of the problem with the cryptocurrency industry in general. It's such a new industry that I think that there are large parts of the government and financial institutions and large businesses that are trying to cut their piece out of it. And in the process, I think they're cutting out the small investor, the small participant. We made a really, really good argument that the Veritaseum token was not a security according to the 1933 Securities Act. And at the very least, that the participants who held Very tokens were non-issuers, non-brokers, non-dealers, and therefore in Section 4A1 of the Securities Act, it says that we can't be by the government the same way the government can pursue an issuer. So we waited for the response from the government for it seemed like forever, at least a few months, if I can recall correctly. And then we never did get an answer from the government in writing. We never did get a phone call back. They wouldn't recognize it. And finally, our attorney, Jeremy Hogan, got a conference with 4 SEC attorneys. Now, the interesting thing here is the SEC has two arms. It has an regulatory arm, and the regulatory arm is usually the arm that grants or denies and no action letters, and kind of gives you some guidance on or why you haven't been given the letter, or why you have been given the letter, and what the rules are that you need to abide by in order to stay in a legal framework. In this meeting between Hogan and the 4 attorneys, the lead prosecuting attorney for the government that prosecuted the Veritaseum case was on the call and was leading the call. And I understand that it's unusual for the prosecuting side of the SEC to participate in a call on the regulatory side. So basically, our attorney spent about 40 minutes on the phone with the attorneys. He pled his case. He said, "There's no reason you guys can't at least give us a written denial and reasons why, so I can help my clients out." And that is at that point they told him that he needed to advise his clients, us, the Very DAO, that we are handling unregulated securities and that we shouldn't do that, and that we are in jeopardy if we do that. So it's my understanding that the SEC doesn't make laws in the United States. That is left to the Congress and the lawmakers. And so what the SEC was doing was basically being a bully and saying, "Listen, we're the big dog on the block. You need to do what we say, and we're not going to tell you." So
So
we
that's
did the
why,
freedom of information. We did. Go ahead.
I'm sorry, that's why, or could that be why they haven't written anything or returned anything in writing, is because they know it's not their place to put, because that legislation doesn't exist yet.
Well, they've granted no action letters to cryptocurrency people. There has been instances where they have granted no action letters.
So to some they do,
My
and
personal
to
opinion
some they
is
don't.
that what's that?
It sounds like a little bit of cherry picking, like some people get a
Yeah,
response
they're
and
picking
some
winners
people
and
don't.
losers. That's
Yeah.
exactly it. That's exactly it. And my personal opinion, and it's just an opinion. There's no legal basis for this opinion. It's just a kind of a feeling that you get over time, is that they really don't like Reggie. They really don't like the Veritasium project, and I don't know why. In my opinion, the Veritasium project is no different than the Ethereum project or the Bitcoin project, and both of those have gotten a pass from the SEC.
Mhm.
But for some reason, they just don't like us, and they've decided to pick winners and losers, even though they're not a legislative body. So the question was, what has the Very DAO done? How have we progressed?
Mhm.
We're truth seekers. We're out there trying to find what we hold, how we can use it, and we want an authority with authority. And I don't think the STC has final say. The legislative body has the final say in this when they make codes and statutes. But we want to know what we hold and how we can use it, because we want to follow the law. And so we've been pursuing that truth for quite some time. Now, there's other projects that we're doing right now, but we figured with the landmark case of the SEC versus Ripple, we needed to get involved because we're the only ones that have the only token holders I know of that have filed an amicus brief that have a story to tell about the chilling effects of the SEC's enforcement by regulation.
That affects the token holder specifically.
That affects the token holder specifically. Exactly. Exactly.
Right.
There have been,
So
I think, 12
mhm.
briefs, MEC briefs that have been filed. They've been filed by exchanges like Coinbase. They've been filed by Ripple partners like I think ICANN is a Ripple
And tap jet.
partner. They've been filed by companies that accept XRP. NetJet, I think, accepts
Gotcha.
XRP.
Mhm.
They've been the Digital Chamber of Commerce, I think, has filed, and they're a nonpartisan, non-positional filer. But we're the only ones that have filed who have a story to tell about how the SEC's overreach has affected retail market participants.
Definitely. I wanted to just touch on a little bit because we are using this as an education platform. And like we said, this is, such a new thing. And that's part of the issue that we're facing. The amicus curiae comes from the term amicus, which means a friend of the court. An amicus curiae is an individual or an organization who is not a party to a legal case, but who is permitted to assist a court by offering information, expertise, or insight that has a bearing on the issues in the case. The decision on whether to consider the amicus brief lies within the discretion of the court. So we would be submitting to the court about this is not about re-litigating the Veritaseum case. We are simply saying we have experience that we believe that Judge Torres and Judge Netburn, that it would benefit them to hear from token holders our experience of the SEC's overreach and the outcome, the aftermath of that. Correct?
Yeah, that's right. If I can, we've put our brief on Twitter for everybody to review, to see,
Mm.
who we are, what our logic is, and how to follow us. And we've experienced tremendous response. Want to read the reply of one of the people that's responded to our brief being filed. Um, Dibspot.com says, I respect this brief. All others up till now have basically been conjecture on the impact of the SEC's argument. This, however, is a cogent and potent example of the exact impact to market participants. Judge Torres should place this on top of the pile. So,
Wow.
in general, people are getting the idea in this. In Brad Garlinghouse replied a little bit earlier today that wow, 12 Amici briefs have been filed on behalf of and supporting Ripple's motion for summary judgment. He was told by his counsel that it's very unusual for that many briefs to be filed into a case at this juncture in the litigation. So, yes, we think this is a landmark case. And for those that aren't involved in a lot of big corporate law, or don't go to court, which is most of us, uh, the amicus is a opportunity for market participants or organizations like the Very DAO to give a relevant and fresh view to the judge about how token holders are being affected by the SEC's overreach. And a lot of people will say, "Well, why didn't you do this when the litigation started, a year ago, or why didn't you get in, a little bit later on?" You have to be following a litigation closely and time the friend of the court filing based on a motion that relates to your specific situation. So the Very DAO has been following the case pretty closely because we are an example of the chilling effect that the government has on market participants when they overreach. And we don't want the same thing to happen to XRP token holders that happened to us.
Right. Or any other token holders in the secondary market. It really is a we the people point of view. And the irony
That's
is
right.
is that that's who the SEC is tasked, or their mission statement is that's who they're supposed to be protecting. Um,
That's right.
so it's very this
That's right.
amicus is very telling, I think. Um,
Yeah, there's a section in the document, and I think that we're going to go over this page by page so that we can kind of reveal, uh, our motivations and our intentions and who we are. But like I said
mm,
before, we're EMT truck drivers. We're we're engineers. We have engineers that do computer systems. We have engineers that build networks. We have coders that are very sophisticated, but we have small business owners, moms and dads, very, very passionate, dedicated folks that are in our group, and we're representing the little guy here. And we feel that unless the judge, Torres and Judge Netburn, have a good perspective on who's being affected by the SEC's actions, they're not going to be able to properly get a good perspective on how to rule in the summary judgment.
I agree. Well, let's dive into the document a little bit and
Okay.
kind of tell everybody what's in this. I think this was really thoughtfully put together and really addresses, those issues that are happening right now in the case. So
Yeah,
where we,
big shout out to Kenny Hertz Perry. Big
yeah,
shout out to Kenny Hertz Perry. The
yes,
attorneys that represented us did a fine job, did their homework, were very empathetic, great listeners. So I want to give a big shout out to them. And I want to take this opportunity to thank the many members of the Veritaseum community, the XRP community, and the general cryptocurrency community that donated to the Legal Defense Fund for the Very DAO. Thank you.
absolutely, yeah. Once again, it really is a we the people movement and supports the First Amendment of free speech and being able to have that
That's right.
voice in the court is just so important. So huge thing to be a part of. Let's see. Where would you? I'll let you kind of guide us on this. Where you'd like to start? What parts we should kind of break apart here?
So yeah, the amicus brief kind of wants to, since the judge doesn't know us, the amicus brief, the first part of it is describing who the attorneys are representing and what motion that we are filing a brief on. Um, the Very DAO wanted to file a brief in support of the motion for summary judgment by the defendant Ripple Labs Inc. and Bradley Garlinghouse and Christian Larson because um, we believe that their attorneys made a very good argument about investment contracts. There's a big controversy about investment contracts. Basically, what the Ripple attorney said is produce the investment contract between the XRP token holders and Ripple, and we don't think you can do it. And so, without an investment contract, you can't have a security. And so that was the big push for the Ripple attorneys. And with the Veritaseum project, it was very interesting because in order to purchase Veritaseum during the IDO, the initial distribution offering, had to sign a knowledge of a product information, and you also had to sign a consent saying that you knew that this was not a. I'm paraphrasing now, so don't go back and read it and say, oh, that's not exactly what it said. But you basically had to basically sign a document that said, I know that this is prepaid access for software, which is in no way near a security or the sale of unregistered securities. So,
Right.
beyond there being no investment contract, Veritasium went out of its way to make sure that we knew that we were prepaying for access to software. So, we supported the Ripple attorney's assertion that without an investment contract, there could be no security, and the SEC has no place in regulating digital assets. So that's the first paragraph. We're for the defendants, Ripple Lab. Then the identity and interest of the amicus curiae goes into who we are, and I've already described that we're just a bunch of moms and dads and business owners and engineers and entrepreneurs that are passionate about peer-to-peer capital markets and what Reggie is doing. Um, so then it went into the very central persons initial distribution in April and May of 2017. And it describes the very token. It says the very token is not a network. It's not a blockchain. It's not Ethereum. It's not Bitcoin. It's not ADA. It is a utility token that exists on the Ethereum blockchain. Um, And it goes on to say that the tokens were intended to serve as utility tokens in order to, one, gain access to the Veritaseum platform, and two, function as prepaid licensing for now patented software services from the Veritaseum platform, much like subscription services to other technology companies like Microsoft.
Mhm.
So, I don't know what your opinion is, but that's always been my understanding of the token, was that it was access to the platform and prepaid services for patented software.
Yeah, this is where, looking into all this and being educated about it, learning about all this, and understanding how counter what the SEC is actually doing, counter to what their mission is. They're actually stifling innovation in the
It's
US
counterintuitive, yeah.
and harming the individuals that they're supposed to be protecting. So it's double-handedly against their own mission statement, um,
Yeah.
because they're driving
Yeah, and
innovation
our
out of
attorneys
the
our
US.
our attorneys our attorneys drilled down on that pretty hard.
Mhm,
I mean, they said, listen, the mission statement of the SEC is to protect retail, and I'm paraphrasing here, they list it very specifically, basically is to protect retail and guarantee the safe formation of capital. And
mhm.
that's the very first part of their mission statement, is to protect retail. If their mission statement is to protect retail, it's kind of puzzling how thousands and thousands and thousands of digital asset holders have come out against the SEC and in favor of Ripple. So far, 12 briefs have been submitted, and not one of them has been on behalf of the SEC.
Well, it would be like a police station saying, "We're here to protect and serve," but they won't answer the phone when you call. The fact that they won't, wouldn't
Exactly.
respond to all
That's
the
exactly right.
NAL and the FOIA and all the requests, that they're there to protect
Yeah, I got to say
and
that's
serve.
probably been the most frustrating part of our communications with the government. You know, we're we're asking for guidance. We've got certain rights as citizens. We certainly have a right, as you said, for freedom of speech. But we're going out of our way, spending our own money, taking time out of our work days, taking time away from our families to say, hey, Mr. GOV, Mr. Government, how can we act lawfully in this instance? And it's almost like the government got a big old cream pie and shoved it back in our face,
Right, when they're supposed to be working
and
for us. Yeah.
that's right. That's right. They're our employees. Our tax money goes to paying their salaries
Right.
and their agencies. And I think that we've acted in good faith, and it's just frustrating to see that good faith being abused by the government.
Definitely. So then it goes on to talk about, let's see, in August, the SEC brought the Veritaseum lawsuit against the very central persons, claiming that the very tokens were securities sold as unregistered and by fraud, which
Yeah,
we're not litigating that old case that was settled. There were no fraud charges
I
filed.
gotta say something here, though. I gotta say something about the fraud thing that they brought up here, because I
Yeah,
think it's
we
very
can
important for
clarify.
people to know this. The irony about the government's assertion of fraud against Veritasium and Reggie Middleton is they said he enticed investors to buy into his IDO, to buy the very token, by fraudulently claiming that patents that he filed would be granted in the future. One, that's evidence of nothing. You haven't proved that he's done any deceit or any fraud, because he actually did file those patents and had every intent of those patents being granted. But that was one of the main arguments that the government complained about him, and brought the lawsuit against him, and really crushed his project and took 96% of his assets. Well, ironically, 7 years later, after defending his innovation, his invention, for 7 years, the Japanese Patent Office and the US Patent Office granted his patents. So the number one claim that the government had against him is he
Mhm.
was acting in fraud and deceit, and tried to deceive retail holders into supporting his project. because he was lying about his patent, his belief that his patents would be granted, and then
They're grand.
they were granted.
Right.
So the irony there is thick. And
Mhm.
the problem, been getting this on Twitter, the problem with the government making a claim against you is that everybody looks at the lawsuit and says, oh, he must be guilty of something, when
Right.
the exact opposite is true. The government made up these allegations against him and prosecuted him on a wholly unfounded basis. And I just saw a really interesting um, interview with a cryptocurrency enthusiast and a former SEC attorney. And she basically said the SEC never loses cases. Never. And the reason the SEC never loses cases is, one, they have the power of the US government with the authority to put you in jail. And two, they have unlimited money dedicated to their budget so that they can um, hire really good lawyers and string out the case. And she said the interesting thing about the Ripple case is it looks like they're going to lose because they picked a battle with somebody that had assets and hired a great legal team. So finally, the SEC has picked a battle with somebody that is superior to them in intelligence and firepower. And I think that the Ripple Labs, Brad Garlinghouse, they're going to clean up and beat the SEC, and I couldn't be happier about that, to be honest with you.
Well, I think it'll be a win for the irony is that it will be a win for the individual investors who the SEC is supposed to be protecting.
Yeah, yeah.
That's
I
the
think the
irony of it.
SEC has the SEC has grown a little bit too big for their britches, as my dad used to say.
Mhm.
Whenever I would get a little bit ahead of myself and I would think too much of my abilities or too much of where I was in life, he would look at me and say, "You're getting a little bit too big for your britches." And that overconfidence always leads to mistakes, and mistakes that are quite painful sometimes. So, not that I wish ill on the SEC or any other government agency, but if you look
No,
at
but a
the
way
way
to
that they're behaving.
yeah, a way to correct that is to bring the light to it, to bring it out into the light,
Yeah,
and I think that's what's happening here is that the community, is coming together and saying, there needs to be light put on this because the court cases do happen typically kind of in a bubble. Um,
that's right.
and in the courtroom, the courthouse, it's like, well, this motion, that motion, this law, that, there's a dance to it. And this is an opportunity for the judges to hear what is going to happen, what could happen, how it will affect the real world
Yeah,
after whatever decision is made down the road. And so I think it's very telling. And I that's where I really had a lot of respect for the way that this was put about because this was not about retelling or restating or relitigating the Veritaseum issue. It was, look,
yeah,
we need this happened. And now here were the consequences to the token holders.
yeah.
And
No, that's exactly right. And I think we probably picked the exact right moment with the exact right motion before the judges, in order to get um, the idea through that this is probably in the wrong jurisdiction. It's not a security, and if as you read in the document here, as we're looking at it, in the complaint, the Veritasium lawsuit, the SEC did not identify the very token
right,
as being any particular type of security under the laundry list of definition of security in the Securities Act of 1933. So even though they told our attorney that we were handling unregistered securities, in the complaint, they didn't even bother to define what type of security it was according to precedent and prior case law. So
right.
I
So
thought
it's
that
not
was an
like they
interesting
didn't
point
have
as
an
well.
opportunity to do that. They just chose to neglect to
Yeah.
even mention it. And then you ask for clarity and are ignored and then admonished, as they would say.
Yeah. that was the funny thing. Our attorney said, "You were really actually admonished, weren't you?" And I said, "Yeah, that kind of felt that way."
It
And if you
was.
talk to Mr. Hogan about it, yeah, if you talk to Mr. Hogan about it, he said they were shaking their finger across the phone at him, saying, "You better tell your clients not to handle those unregistered securities."
Yeah,
And
and
then he
so
came back and said, "Well, they're not issuers, they're not dealers, and they're not brokers. Don't they get the Section 4 cut out?" And he said they didn't say anything. They couldn't say anything because
so explain that, unpack that a little bit, because I'm not sure that everybody knows about that. This was new to me as well. That as a secondary, what is the section for?
the
I
Section 4
don't.
cutout basically is part of the 1933 Securities Act, where it says the government has responsibility to protect the retail investors by regulating issuers of a security, brokers of a security, or dealers. And if you
Okay.
don't fall into, I'm paraphrasing again, if you don't fall into one of those three categories and you're a retail holder of an asset, then the government has no business prosecuting you, regulating you, or coming after you for any reason. So that's the cutout that
Mhm.
eventually our attorneys address later on in this document.
So that's how like baseball card traders and all that are protected. They're considered
Right. And listen,
after
we'll
second
go over
level.
this a little bit later.
Yeah.
We'll go over this a little bit later, but one very important part of the document, our attorneys really kind of question whether the SEC has jurisdiction over digital assets at all. Their
Oh.
their point
Mhm.
was that it's probably more in the realm of the CFTC. It's probably more akin to a commodity than it is a security.
Okay. Okay. So
So we'll hit
here,
that later,
yeah,
but I'm very pleased with the really impactful and cogent argument that the attorneys made on our behalf.
definitely. So here we were discussing just bringing them up to speed on the Veritaseum lawsuit, the security sold, the the claims, what ended up the settlement that happened, the fact that the SEC had every opportunity to designate the tokens at that time, and they did not. Then we kind of get into more of the I guess more of this investment contracts, and that's where it ties in with the SEC versus Ripple case.
Yep, that's the motion in front of the judge right now. Basically, the Ripple attorneys made the case that there is no investment contract, therefore there can be no security. No reasonable jury would rule in favor of the government at this point. Let's go ahead and end this thing and call it a day. And our attorneys did a very good job at saying, um, you know, without mentioning the exact term investment contract, the SEC seemingly implied a belief that the very tokens were investment contracts by stating in the complaint that the very purchasers would have reasonably expected to profit from the very central persons. The very central persons, by the way, just means Reggie Middleton, Veritaseum Inc., and all the Veritaseum entities.
Mhm.
Um, and continue to convey that the economic substance of purchasing a very token was the making of an investment in a common enterprise with a reasonable expectation of profit. Roughly tracked with what the Howey test is. That's been the kind of the gold standard of whether you have a security or not. So that I think they did a fantastic job at kind of teeing up what the SEC was trying to argue, and then tearing down their argument in the very next paragraph. Here's the next part of it. On November 1st, 2019, Reggie Middleton, Veritaseum Inc., Veritasium, without admitting or denying any of the factual allegations made against them in the SEC's complaint. Now that's a big statement right there. In the complaint, the SEC can throw the kitchen sink at you and say, "Oh, you're a fraud. You're trying to deceive. You're trying to act in deceit. You're acting in bad
Mhm.
faith. You're trying to steal money from retail." They can call you anything they want in their complaint. But when they settled, They didn't. Reggie and Veritaseum didn't make one um,
Admission.
statement
Yeah.
admitting or denying.
You were talking about how important it was that they could accuse you of anything in the complaint, but it was
Yeah,
very important that on November 1st, 2019, the very central persons, without admitting or denying any of the factual allegations made against them in the SEC's complaint, entered into a consent judgment to resolve the action. Um,
right. Basically, they took 96% of his assets and they were bankrupting him through the court system. So in the final judgment, the Veritaseum lawsuit, we kind of came together as a DAO. None of us were named as defendants. We weren't an actual body then. We were just kind of a loose affiliation of folks who were concerned. So, no final determination was made in the settlement about the approximately 2.15 million. I think it's less than that. I think it's less than 2.15 million tokens that exist in the secondary market. But there was no mention of the very tokens in the final settlement, and there was no mention of the very token holders. So that's
mhm.
basically when we came together and we said, "Hey, wait a minute! There's real people out here that need to be addressed." Um, so that's where we are in the story so far, and we're just on page 3 here, I think.
Yeah, it's an exciting story, and
It is.
the other thing is that it's gonna, it can affect so many other companies. We're seeing the SEC go after a lot of these innovating companies here in the U.S. that are trying to, you know, build that American dream and build the
Mhm.
future and have it happen here in the US and let us be part of it instead of everything having to be shoved outside the US borders and innovation, falling in the hands of, uh, you know, all the other countries such as China and um, Russia, wherever you want. Pick a country that's that's going to be ahead of
Yeah,
that's going
no,
to be
listen,
ahead of the US. We're going to be behind the ball.
the even companies like JP Morgan, we did as a DAO, we also did a lot of analysis on market participants that might be good partners for
Oh
Veritasium, and
yeah.
JP Morgan is settling billions and billions in transactions cross border in the Asian market today, and not by not using the Swift system to settle those um, assets in the market overnight, they're saving millions and millions of dollars for the company. So there's already people out there, already entities out there, ex-US, outside the US borders, that are racking up record profits because of Reggie Middleton's invention.
Well, and this brings to the point. So I heard Garlinghouse speak the other day, and he said, really, we've already won because Ripple will go on regardless of what happens. And when he said that, I thought,
Ripple's clients are mostly in Asia. They're mostly in
but
Japan.
the XRP token holders in America would be harmed
Yeah, there's
by
no
the
doubt.
SEC's actions. And
There's no doubt.
that's where they would be in the same situation, and that's where you can see this happening over and over again with whether it be a if a business was built on um, a, a, co- a company that the SEC went after. um, I don't want to name any names, but you never want to point any attention
Yeah.
at anybody, but the SEC has gone after other projects, and it has rippling effects, pun
It has a
intended,
chilling effect.
chilling
It has a chilling
effects and
effect
rippling
on the
effects
market.
on individual token holders and innovation in America, and really having those things go elsewhere. So it's it's a powerful thing right now. So we got into the investment contracts, and that's why this was the right time to bring this to the court and be a friend to the court with the amicus. And
Yep.
let's see.
Well, it goes on to say the inconclusive results left the downstream, unaffiliated, and secondary holders of Very tokens with no confidence or guidance on what they possessed and what they could legally do with it. Now that's the truth. So they're acting antithetically to their own mission statement, which is to protect the retail holders. Instead, they've chose to give us no guidance. Um, and the reason that I think the reason that they don't give us any guidance is probably because if they did, it would cut into their power. I mean, if we're being honest, they're doing a power grab right now. They're trying to get their agency as much power as possible. And if they responded to kind of the low on the totem pole folks like you and me, they would have to give some of their power back to the people, and they don't like that.
Yeah, so if you put the lines on the street and people know where they have to drive, then they know where they or where they can't drive, then they know where they can drive. And
Right.
that video of Gensler when he was teaching at MIT, where he specifically says there are mechanisms in place for the current market makers to slow innovation, to keep power, really resonates with this. You know, if they're using that as a mechanism, if they never let you know where it's safe to drive, then you can't go anywhere, or at least not in the United
Yeah.
States.
Well, they've got an opportunity to fine people for not knowing where to drive. The folks at Block One who own EOS had to pay $20 million. Reggie paid, I think, $9.5 million plus a bunch of his other assets. And to say, "Oh, we're for the people. We're going to help the little guy recover his money." They formed a very fair fund, to compensate very holders who had been deceived and defrauded by Reggie Middleton. But it's been 3 years since the settlement, and they still haven't paid out one red cent to any Very token holder. So they're just holding that money in a slush fund, and guess what?
Who's getting the interest on that?
By law they get to keep all of that money. I listen. It sounds like highway robbery to me. But if the SEC doesn't let you know where to drive, but can give you a ticket for not driving where you don't know you can't drive anyway, then they got. I think they got a fine from Library, they got a fine from
Mhm.
Reggie, they got a fine from EOS.
They're working
Brad
on a few
Garlinghouse has
others.
said they've spent
Mhm.
$100 million defending Ripple Labs here in the U.S. I mean, those guys. I don't. They're just. In my opinion, they're just unscrupulous.
That's really interesting. And it's interesting to see what
So.
projects are targeted and what projects get the pass.
Well, they picked on a bunch of people with a little bit of cash in the bank, and guys and gals that they were sure they could bankrupt. Then they picked on Ripple, which was, $5 billion in the bank and a big war chest and the gumption to protect their name and their project. And I think they picked on the wrong folks. So I was just going to finish up that thought by saying, our attorneys said this is problematic to holders of the very token because as individual token holders, we had to utilize our own efforts and pursue our own use of the tokens in order to produce profits and value. And the real punch to the gut of the SEC in their argument about the Howey test is, there is no common enterprise that holds the very token holders can rely on to produce profits or value. So we're kind of out here doing it on our own.
Mhm.
Reggie Middleton is not a member of the Very DAO.
Mhm.
He does not hold any Very tokens. There are some members of the Very DAO that own tokens. There are some members that don't and are just passionate about peer-to-peer technology. But if we're to be a nation of laws, if we're to be a country where freedoms matter, we have to have regulatory bodies that give us guidance. Without that guidance, we're kind of drifting in the wind, and we're kind of at their mercy because they've got all the guns and all the money, and we're left saying, "Hey, I thought you guys were here to help us out." The most powerful parts of this filing are ahead of us. The most powerful parts are the argument and the conclusion. And I think that once the public understands that we're not only fighting for the Ripple Labs motion for summary judgment and the XRP token holders, we're fighting for Veritasium token holders, and we're fighting for everybody that is adversely affected by the unfair balance of power of the government
Right.
against the
This,
people.
yeah,
And I think you aptly stated that we are fighting for we the people.
absolutely. Well, thank you so much for helping me break this down. You guys will be returning for more breakdown of the amicus brief that the Very DAO has filed. Stay tuned and make sure you subscribe to the channel for more.